The kettle was just starting to whistle when everything went dark. My daughter Emma let out a confused cry from the living room where she'd been watching cartoons. Through the window, I caught sight of a figure standing at my property line, clipboard in hand and a satisfied smirk on her face. Patricia Harrington, our HOA president, had finally done it. She'd actually managed to get the power company to shut off electricity to my cabin. What she didn't know was that I held the deed to something far more valuable than a few circuit breakers. I controlled the water rights to the entire lake. My name is Lucas Brennan, and I'm what you might call a reluctant property owner. I inherited this lakefront cabin from my grandfather 3 years ago, along with some dusty old papers I'd barely glanced at. As an environmental attorney, I spent my weekdays buried in contracts and litigation. The cabin was supposed to be our escape, a place where Emma and I could fish, hike, and forget about depositions and court dates. I never wanted to be involved in neighborhood politics. That changed the day Patricia Harrington was elected HOA president of Pine Ridge Estates. Patricia was one of those people who confused a clipboard with a crown. Within weeks of her election, she'd instituted new rules about everything from mailbox colors to the acceptable height of bird feeders. Most residents grumbled but complied. I made the mistake of thinking that keeping to myself would keep me off her radar. I was wrong. It started with a notice about my fence. According to Patricia, the split-rail design that had stood for 40 years was suddenly non-compliant with HOA standards. Then came complaints about my porch lights being too bright, despite them being the same solar-powered fixtures half the neighborhood used. When I politely pushed back with a letter citing the grandfather clause in our covenants, she took it as a declaration of war. The harassment escalated quickly. She started timing how long visitors stayed at my cabin, claiming I was running an illegal rental operation when my sister visited for a week. She filed complaints about my dock, saying it extended 2 inches too far into the lake. She even tried to fine me for the native wildflowers I'd planted, calling them weeds that violated landscaping standards. Each time, I responded with calm, legally sound rebuttals. Each time, her face grew a little redder, and her tactics a little nastier. The power shut-off happened while Emma and I were at a school science fair. Patricia had apparently convinced the utility company that my cabin posed a safety hazard due to alleged code violations. She'd submitted falsified inspection reports claiming exposed wiring and overloaded circuits. By the time we returned that Friday evening, the cabin was dark, and the refrigerator was already starting to smell. Emma was scared and confused as I fumbled for flashlights. At 7 years old, she didn't understand why someone would do this to us. I set her up with a battery-powered lantern and her favorite book while I went to the basement to check the main breaker. That's when I found the notice from the power company, complete with Patricia's signature as the reporting party. My hands shook with anger as I read her fabricated list of violations. That night, after I'd gotten Emma to sleep in her sleeping bag by the fireplace, I started digging through my grandfather's old files. I was looking for documentation about the cabin's electrical work to dispute Patricia's claims. Instead, I found something far more interesting. It was a leather-bound folder containing the original water rights deed from 1922, along with a series of legal documents I'd never properly examined. My grandfather hadn't just owned a cabin on the lake. He'd been one of the original developers who created the lake itself. The documents showed that our family maintained senior water rights to the entire body of water, including control over the dam that regulated its levels. There were easements, usage agreements, and, most importantly, a clause stating that these rights could be enforced at the owner's discretion to protect the property from harassment or illegal interference. I spent the weekend making phone calls to colleagues who specialized in water law. By Monday morning, I had a plan that would make Patricia's power play look like a child's tantrum. I contacted the Water Management Board first, filing notice of my intent to exercise my senior rights. Then I called the company that managed the HOA's irrigation system, informing them that their water usage agreement was under review due to concerns about the HOA leadership's illegal activities. The effects were almost immediate. By Tuesday, the sprinkler systems that kept Pine Ridge's common areas green had mysteriously stopped working. The lake's level began dropping just enough to expose muddy shorelines in front of the most expensive properties. Patricia's own prized lawn, which she spent thousands maintaining, began showing brown patches within days. My phone started ringing off the hook. Neighbors wanted to know what was happening to their lake access. I calmly explained that I was exercising my legal rights in response to illegal harassment and that normal water levels would resume once the HOA addressed the criminal behavior of its president. Word spread quickly through the neighborhood. Patricia tried to rally support at an emergency HOA meeting, but the tide had already turned against her. When she stood up to speak, her voice cracking with barely contained rage, homeowners demanded to know why she jeopardized their property values with her vendetta. The board voted to launch an immediate audit of her actions. That's when they discovered the extent of her abuse of power. She hadn't just targeted me. The forensic accountant found dozens of cases where Patricia had levied suspicious fines, many of which had been paid directly to accounts she controlled rather than the HOA treasury. She'd used HOA funds to hire a private investigator to follow residents she didn't like. She'd even falsified meeting minutes to push through rules that had never been properly voted on. I filed formal complaints with the State Attorney General's office and the Utility Commission. The falsified inspection reports she'd submitted to cut my power constituted fraud and filing false statements, both felony charges. The misappropriation of HOA funds added embezzlement to her growing list of legal troubles. The town council hearing was scheduled for a Thursday morning, and the meeting room was packed. Patricia sat at the defendant's table, her usual designer outfit replaced by a conservative suit that couldn't hide her trembling hands. Her lawyer, looking resigned to his fate, shuffled papers nervously as I took the stand. I presented the water rights documentation, explaining in clear terms how Patricia's illegal actions had forced me to protect my property using the only leverage available. The council members listened intently as I detailed each instance of harassment, backed up by meticulous records and correspondence. When Patricia tried to interrupt, claiming I was exaggerating, the council president shut her down with a sharp rap of his gavel. The evidence was overwhelming. The falsified inspection reports alone were enough to establish a pattern of criminal behavior. When combined with the embezzlement and abuse of power, the council had no choice but to act decisively. They ordered the immediate restoration of power to my cabin, with all costs to be paid by Patricia personally, not the HOA. But that was just the beginning. The criminal charges resulted in Patricia being found guilty on multiple counts. The judge, clearly disgusted by her abuse of a position of trust, didn't hold back during sentencing. Patricia's face went white as he read out the penalties: 3 years in state prison for the felony fraud charges, another 2 years for embezzlement to be served concurrently. She was also ordered to pay restitution of $187,000 to the HOA and its residents, plus $50,000 in fines to the state. As the bailiff moved to take her into custody, Patricia's carefully maintained composure finally cracked. She broke down, sobbing, mascara streaming down her cheeks as she babbled about how this wasn't supposed to happen, how she was just trying to maintain standards. The courtroom was silent, except for her wails, as she was led away in handcuffs. Her days of wielding a clipboard like a weapon were finally over. But the story doesn't quite end there. During the investigation, something else had come to light about Patricia's past. It turned out this wasn't her first rodeo with HOA harassment. 5 years earlier, in the neighboring town of Cedar Falls, she'd been removed from another HOA board under suspiciously similar circumstances. She'd managed to bury that history when she moved to Pine Ridge, presenting herself as a successful real estate broker with a passion for community standards. The real estate board caught wind of the criminal conviction and launched their own investigation. Within days, they discovered she'd been using her position to steer clients away from properties that didn't meet her personal standards, even lying about property values to manipulate sales. Her broker's license was revoked immediately, and several former clients came forward with lawsuits of their own. Her husband, a mild-mannered accountant named Roger, who'd spent 20 years apologizing for his wife's behavior, filed for divorce the day after the sentencing. He'd apparently been documenting her behavior for years, just waiting for the right moment. The divorce papers revealed that Patricia had hidden nearly $500,000 in various accounts, money she'd accumulated through her various schemes over the years. The IRS got involved when they discovered she hadn't reported most of this income. Tax evasion charges were added to her growing list of crimes, tacking on another potential 5 years to her sentence. The federal prosecutor, a no-nonsense woman named Janet Morrison, seemed to take personal pleasure in dismantling Patricia's financial house of cards. Meanwhile, I had restored water flow to the lake, but not before the damage to Patricia's lawn had become irreversible. Her house, which she'd leveraged to the hilt to maintain her lifestyle, went into foreclosure. The bank held an auction on a sunny Tuesday morning, and I couldn't resist attending. There were only 3 bidders, and I won with an offer 20% below market value. I didn't want the house for myself. Instead, I worked with the county to convert the property into a protected wetland area, a buffer zone between the development and the lake that would preserve the natural habitat forever. We planted native grasses where Patricia's perfect lawn once stood and installed an educational kiosk explaining the importance of watershed protection. The final irony came when Patricia's former allies on the HOA board discovered a clause in the bylaws she'd written herself. It stated that any board member convicted of a felony related to their HOA duties would be personally liable for all legal costs incurred by the association. The HOA's legal bills from the whole debacle totaled over $300,000. Even from prison, Patricia was getting bills from lawyers she'd never hired for a mess she created entirely on her own.